Hi guys, today we are going to do our group video presentation assignments on legal skills and methods. Our group consists of 5 members, which is me, Shengjie, Terence, Juntao, Yufu, Weijie, and Justin. So the topic of our presentation is basically about our opinion on should death penalties be sentenced on child who committed crime. So this presentation has been divided into 4 parts. Firstly, we will do a short introduction on juvenile delinquency. Later on, we'll be looking on our opinion that it's a good law for a child who committed crime to charge with death penalties. We will be looking on the perspective that it's a bad law. And lastly, we will do a final conclusion on our opinion regarding this issue. Now let's get into the topic immediately. So what is meant by juvenile delinquency? Juvenile delinquency is actually defined as youth offenders who participate in unlawful acts or behavior below the statutory age of majority, which is 18 years old in mostly countries, such as in our countries Malaysia and in UK but excluding Scotland and also in Australia. According to the Article 1 of Convention on Rights of the Child, it is defined that a child is everyone under the age of 18. According to the Child Protection Act 1999 in Australia, it is stated that every individual under the age of 18 is a child. So, juvenile delinquency encompasses some unlawful behavior such as theft, vandalism, alcohol and drug offense, rape, and murder. Now let's look into the cases of juvenile delinquency in Malaysia. So between the year 2003 and the year 2009, children cases that were registered in the courts is basically between the number of 2,000 to 3,500, and most of the crime committed by children is theft and drug abuse. But the cases have been increased substantially in recent years, such as in 2016 and 2017 and the year of 2018, which were recorded 4,886, 5,443, and 5,294 respectively. According to the Section 2 of the Child Act 2001, a child is defined as an individual below the age of 18, however reach the age of 10 or is above the age of 10. And according to Section 82 of the Penal Code, a children below the age of 10 cannot commit a crime. This is because they will not be tried in any courts although they commit some crime. And children have a different courts proceeding compared to adults. Children for the age of 10 to the age of 18 can be tried in a court of children for committing crimes. But after they reach the age of 18, they will be tried in a normal court. However, there's also some exceptions where children will be tried in a regular court. According to Child Act 2001, Section 11, subsection 5, we stated that if a child committed a very serious crime or an offense which is punishable by death or imprisonment for life, such as grave crimes which include murder, unlawful possession of firearms, drugs, and kidnapping which is dangerous. For crimes that are not classified as grave crimes, there will be different punishment sentence for a child who committed it. According to the Child Act 2001, Section 96, subsection 1, a children below the age of 14 should not be ordered to be imprisoned for any offences. However, it can be alternated by payment of fine or compensation or be sent to Henry Gurney School. However, for children above the age of 14, a jail sentence would not also be first choice either. After a child has committed a crime, they will be sent to the courts of children, which are presided over a magistrate, and 2 court advisors, which one must be a woman. After that, they will be sentenced to different punishment, which include a probation order for a period between 1 to 3 years for offences which are not too violent. Besides, children that is 10 years old and older will be sent to an approved school for a fixed period of 3 years for offences that is not too violent in nature. Child aged 14 years old and older will be sent to the Henry Gurney School for at least 3 years or until they reach the age of 21 for serious offences. Imprisonment can also be sentenced to a child if a child commits an offence which a death penalties apply, under the pressure of Yang di-Pertuan Agong, which we will be discussing on the following slides. If a child has committed a grave crime, the Child Act 2001 Section 97 will be applied in the cases. A children may be ordered by the court to be detained in the prison under the pledge of Yang di-Pertuan Agong, the ruler of the states, or the Yang di-Pertuan Negeri. To illustrate in the case of public prosecutor versus KK, a minor was accused for killing his tuition teacher's 11 years old daughter. He stabbed her 20 times as he was provoked by the victim, who had apparently laid out the knives, daring him to hurt her. The child was tried in a high court as he committed a serious crime, and he was sentenced to imprisonment as construed by the Section 97 of the Child Act 2001. Similar circumstance happened on the case of private prosecutor versus Maud Yusri Mohamed, who a boy who was in the age of 18 murdered 23 persons in connection with a fire at Tafiz School. He was ordered by the court to be detained in prison under the pleasure of Yang di-Pertuan Agong.
Hi, my name is Terence. Now I'm going to discuss about why Section 97, Subsection 1 of Child Act 2001 is a good law. Before going to the reason why it is a good law, I'm going to give some extra information about death penalty of minor. There are 6 countries that is still retaining the death penalty of minor, including Iran, Yemen, Pakistan, Saudi Arabia, Nigeria, and surprisingly, the United States. In the whole world, there are a lot of international organizations or NGO protest, disagree the death penalty of minor. The first organization is the Convention on the Right of the Child, CRC. Article 37, subsection A, is stated that neither capital punishment nor life imprisonment without the possibility to release shall be imposed for offense committed by the person under the age of 18. This article emphasizes that the individual under the age of 18, at that time, they committed an offense shall not be sentenced either capital punishment or life imprisonment without the possibility to release. This provision is designed to protect the right of minor and recognize the potential of rehabilitation. The second organization is the International Covenant on Civil and Political Rights, ICCPR. In Article 6, subsection 5, stated that sentence to death should not be imposed for murder committed by the person under the age of 18. This is the last case Geneva sentenced to the death penalty in UK. Then his name is called Howard Haywood Wilkins. He found guilty in the court for killing Ethan Corey with the murder driven by sexual motive. But at the last, this guy didn't sentence to death because of the Children Act 1908 and the Children and Young Person Act 1933. His sentence was commuted due to his age. So, what is the position of Malaysia? Malaysia joined the Convention on the Right of the Child in 1995. Malaysia must act in the best interest of the child to provide a safe place to the child, to give opportunity to the child, the freedom to education. So lastly, Malaysia enact the Child Act 2001 in an effort to fulfill their obligation under the treaty.
Hello, my name is Jun Tao, and now I will be talking about why should the death penalty not be imposed on minors. The first reason for that is because minors are in a period of psychological and mental development. According to a journal about juvenile justice and childhood development, a person's brain will change and grow a lot from adolescence into early adulthood. Major changes will occur in the parts of the brain which help govern executive functions such as self-control and planning. Therefore, adolescents tend to be more impulsive, short-sighted, and susceptible to peer influence. Hence, minors tend to be influenced easily by their surroundings. We can also see from the case of Mullins and Richards that the standard behavior expected of a child cannot be the same as adults, as it disregards their developmental vulnerabilities as minors. Secondly, the death penalty destroys any potential for rehabilitation. A study has found out that children are more likely to be rehabilitated than adults. The reason for this is, as mentioned earlier, children's brains have not developed fully yet and are easily influenced. Planting core values and providing guidance to them during this stage can reshape the way they think and act dramatically. Hence, providing minors with access to rehabilitation and education programs is crucial for their successful rehabilitation. We should focus on rehabilitating a child instead of handing them the death penalty, as this recognizes the potential for personal growth and rehabilitation over time, aligning with principles of restorative justice. Now, I will talk about how we can strengthen this law. The first way to do that is by alternative sentencing. Parliament can formulate a law that if a minor committed a murder, besides being sentenced to death, the minor will be sent to rehabilitation to get consultation or be involved in community service. Secondly, we could also try transferring the punishment. The judges can transfer the punishment to the family that didn't educate the minor enough. For example, the family of the minor will be required to provide monetary and other forms of compensation for the victim's family. Next, we could also try working with NGOs and international organizations. We can do that by finding ways to improve children's rights and improving the juvenile justice systems. Other than that, we could also hear the suggestions of these organizations regarding the best way to deal with child offenders. Lastly, we can review and amend the Child Act 2001. This is to close any loopholes, respond to new challenges, and make sure we are following the international standard of children's rights to ensure the effectiveness in protecting minors. That's all I have to say today. Thank you.
Now I'm going to explain about why we need to amend the provision. According to the principle, everyone is equal before the law. It means that everyone must take responsibility for their action. This principle also asserts that no one can evade or escape their legal responsibility due to their status. Similarly, a wrongdoer, even if they are a child, must bear legal responsibility for their action and cannot evade it due to their age. A wrongdoer who caused the death of another may face to the death penalty as punishment, following the principle, a life for a life. According to the online reference, there were 4,569 criminal cases involving children in 2015 alone. Additionally, many crimes were also committed by child vendors over a period of time. The first case is the R.N. Thompson and Venables. In the case of R.N. Thompson and Venables, 1993, John Venables and Robert Thompson, both just only 10 years old child, at that time were convicted of murdering a 2-year-old child, James Berger, in Liverpool. They lured James away from a shopping center, subjected him to severe violence, and left his body on a railway track. The case raised profound legal and social question about the criminal responsibility of children. And the court held that John Venables and Robert Thompson were guilty of their murder of James Virgil. Despite their age just 10 years old, the court found that they have the capacity of understanding the gravity of their action. They were sentenced to detention at Her Majesty's pleasure, reflecting the severity of their crime. This case underscored debates around criminal responsibility and rehabilitation. I need to emphasize again, in the case R. and Thompson and Venables, the child vendors had taken an innocent life. They committed the crime fully aware of the consequences of their action, but they're still doing so. However, due to the laws at that time, minors were not subjected to the death penalty even they committed a crime. Therefore, they were detained for only 8 months. After the 8 months, they could start over and return to a normal life, but the victim will never return. Is it fair to the victim family? And does this truth serve as a deterrent to others? I don't think so. And the following case was Mary Bell case. In the case of Mary Bell, the defendant, who was convicted of manslaughter in 1968 for the death of 2 young boys, the court held that while she was guilty of the crimes, her age and physiological states were taken into consideration during sentencing. As the offencer was still a child and claimed that she had been influenced by her upbringing and environment, the court sentenced the defendants to detain indefinitely. However, the child vendors was eventually released at the age of 23. It must be restated, the child vendors not only took the life of 2 young boys, but also caused immeasurable harms to the victim family. The victim family had to face interviews from the public media, turning them into topics of casual conversation for everyone. Additionally, they had to endure the pain of losing their children. It will affect them in the rest of their life. A few years of detention clearly cannot compensate the victim and his family. Conclusion: it was obviously, if our country did not impose mandatory death penalties on crimes committed by children, it would cause significant injustice to the public. Furthermore, it would fail to deter other child offenders from committing crimes, and also impact the social harmony. Therefore, amending the legislation is both necessary and essential.
My name is DVJ, indicating how to amend legislation so that the death penalty is not necessarily prohibited when a child commits a crime. Malaysia must export changes to the definition of a child and the differences ages of criminal responsibility for minors, as well as updating which crimes can be subject to the death penalty for offenders ages 16 to 17. Redefining the definition of a child is the first step in this reform. It is currently set for those between the ages of 10 to below 18. However, Malaysia must refine its definition to consider 16 and 17 years old as teenagers. Many teenagers at these ages are already able to take on certain social responsibility, such as part-time jobs. This will also enable them to have a certain degree of independent thinking and decision-making ability, and to be responsible for every action they take, rather than choosing to affect or not have the courage to face responsibility and legal sanctions. The redefinitions recognizes the maturity and decisions making ability of older teenagers, which can help deter serious crimes by teenagers of these ages. The age of majority in Malaysia remains unchanged. There is people ages 18 and above are considered adults, as stated in Section 2 of the Ages of Majority, Age 1971. In addition to define the ages of majority, it is also important to adjust the ages of criminal responsibility. In Malaysia, the current ages of criminal responsibility is 10 above, but offenders ages 16 and 17 are often treated differently in the justice system than adults ages 18 and above. By setting the ages of criminal responsibility for serious crimes such as murder, terrorism, and drug trafficking at 16, Malaysia should ensure that teenagers who commit these serious crimes must be held accountable in the same manner as adults, including the death penalty. These changes will be consistent with the practice in countries where minors can be tried and sentenced as adults for serious crimes, thereby ensuring Justice is served in cases in extreme criminal behavior and bringing the fairness fitting to inconvenient fittings. To maintain a balanced and fair legal system, Malaysian law must set out the criteria for the death penalty to be imposed on 16 and 17 years old. This should be limited to the more serious crimes such as premeditated murder, negligence, acts, and heinous violent crimes with clear intent to cause great harm or loss of life. This criteria ensures that the death penalty is only used the most egregious cases reflecting both the seriousness of the crime and the clear intent of the offender. This approach strikes a balance between the need for severe punishment and recognition of the developmental differences between teenagers and adults. However, the Malaysian Parliament passed a bill to abolish the mentality death penalty in Malaysia on April 3, 2023, which came into effect on July 4 of the same year. Malaysia also adopts a discretionary death penalty for 7 crimes punishable by death, which means deciding whether to sentence the criminal to death or replace it with life imprisonment and caning, including murder, short-tracking, negligent, and hostage-taking incidents involving the death of others. According to Lahim, who is a former Inspector General Police, he disagrees with the government abolition of mentality sentencing. He believes that the abolition of the death penalty will lead to an increase to crime rates and describes criminals as no fools because they will carefully study the law before committing crimes and understand the consequences they may have faced. Therefore, the existence and implementations of the mentally death penalty play an important role in curbing crimes. Once the law establishes, criminal behavior may increase, making them more unscrupulous and completely fairness of legal sanctions, including juvenile offences. I think this bill should be repealed and the mentality death penalty should be limited to offenders as young as 16 years old. To implement these changes, the existing legal framework must be truly reviewed and a strong support system put in place to ensure fair trial and proper defense for juvenile offenders. The justice system of Malaysia must adopt to these changes while maintaining the integrity of the law to protect the rights they accuse. By bringing 16 and 17 olds within the scope of the death penalties, the occurrence of serious crimes can be effectively reduced. As the saying goes, think before you leap. When teenagers realizes that they will face the same severe punishment as adults on the death penalty, they may consider the serious mistakes they have made and avoid making more criminal mistakes again, thereby reducing the crime rate and improving national security. The proposed legislative changes are not only about increasing punishment, but also about creating a legal framework that reflects the seriousness of certain crimes and the capabilities of older teenagers to understand the consequences of their actions.
Alright, thank you everyone for listening, and now let's come to a conclusion. My name is Uyufu and let's go. After exploring articles, websites, and having some discussions with my fellow groupmates, we came to the conclusion that Section 97 of the Child Act 2001 is a good law. Why? We divided the reasons into 4 areas. And first, we have moral and ethical considerations. Measures that are taken against juveniles are widely thought of as unethical and inhuman. Many worldwide and continental organizations like the UNCRC and ICCPR are against the death penalty for juveniles. They also pointed out that the primary goal of the justice system should be to rehabilitate young offenders and help them become productive members of society. Next, we have rehabilitation and the ability to change. The positive aspect is that there is still a high probability of rehabilitation among juvenile offenders due to the existence of a lot of evidence. For example, Mary Bell Remember Maribel that my friend Justin just mentioned? She killed 2 young boys and she was released at 23. She did not reoffend, and this shows that there is potential for change. With appropriate education, psychological support, and vocational training, many young offenders can reform and lead constructive lives. Thirdly, we have scientific research. It is found that the development of their brains, the juveniles' brains, in areas such as impulse control, understanding consequences, and decision making is not yet fully matured, making juveniles have lighter responsibility for their behavior compared to adults, as they lack full control and foresight. And last but not least, we have deterrence was questioned. Juveniles are less likely to consider long-term consequences due to their developmental stage. They commit crimes due to impulsive behavior and actions, and they don't think too far, making the death penalty for juveniles not a good crime prevention tool. Of course, it is understandable that the families of victims seek justice and closure. So, alternative punishments such as long-term rehabilitation programs and secure facilities are needed. Besides sending them to hell, just let them redeem themselves in their remaining lives seems to be better than death penalty. But it is needed to confirm the juvenile offenders' minds are fully rehabilitated after release. This is to prevent them from harming the public. Remember R versus Thompson and Venables in 1993? One of the 10-year-old child, Venables, was released on parole in 2001, but was later recalled to prison in 2010 and 2017 for possessing child abuse images. Venables has expressed a long-standing desire to perform sex on a child and has violated a number of conditions of his license by consuming narcotic substance and by using the internet without permission. The parole board has denied has denied John Venables' request for release from jail, with concerns about the potential for him to view more child sexual abuse images or commit contact offenses with children. So it's needed to make sure that they won't give harm to the public after release. We also discussed whether juveniles aged 16 to 18 should be punished with the death penalty. Some argue that since these juveniles can often foresee the consequences of their actions, including the act of murder, and that is difficult to change the character of a 16-year-old teenager. Should we consider the death penalty to ensure they can't harm the society again? However, the answer is no. Let me explain why. While a teenager has a conscious awareness of the consequences of their actions, he or she cannot control the impulse. This is the case since the prefrontal cortex region of the brain that is accountable for individuals' decisions and ability to control their impulses does not develop fully until they are 20 years old. Hence, juveniles do not possess the quality of being able to regulate one's actions. They should not be held to such a level of responsibility because their brains are still as undeveloped as those of adults. So, the conclusion is, yes, Section 97 of the Child Act 2001 is definitely a good law. Thanks for listening. Thank you.